I understand that we are back on TV.
For the moment, yes.
Hopefully it will allow us to finish before it interrupts us again.
Yes.
Let's proceed. Thank you.
Thank you, Chair. Lord Hayne, we were at paragraph 69 before the long adjournment, where you make some comments in relation to states. You've dealt with some of the issues in that paragraph, but do you have anything to add?
Only, Chairman, that I think it's important that states, if they want to have good reputations, raise their standards on the one hand and collaborate more between each other on the other, because this can't be done by one state alone, whether it's South Africa or any other country. The global financial criminal network is that it's global, and therefore states have to operate on a global basis, cooperating with each other, and that isn't happening, frankly, to the extent that it should do, and it needs to, because otherwise this will continue.
You made the point earlier in regard to banks that even from a technological point of view, criminals might be ahead of the game. And I take it you're making the same point in regard to states within national borders.
I am, Chair, because it seems to me, having looked into this prior to submitting my evidence to you, that frankly, there's a lot of policy statements and speeches made about money laundering and financial crime. But when it comes to preemptive action and ensuring that the safeguards are there, the obstruction, walls are there to stop all of this money laundering and financial crime, really, we are nowhere, so to speak. We're way behind the game, most governments in the world, and certainly in their collaboration. And there are particular villains amongst the different global governments, and I think they should be exposed and have to account for their backtracking and backmarking on this whole agenda.
You then deal in paragraph 70 and following with the matter of legislation. And you make the point in paragraph 71 that not only is it important to have legislation in place, but to ensure the adequate enforcement of that legislation.
Yes, indeed. I mean, Chair, in paragraph 70, I recommend the proper utilization of existing legislation. South Africa does have, for example, good legislation in the Prevention of Combating Corrupt Activities Act 2004 and the Financial Intelligence Act 2001. Nevertheless, we've had this whole picture of rampant criminality and state capture. So it needs to be properly enforced. There need also to be additional measures to hold public officials to account for misusing information gathered during an investigation, because there needs to be a much higher standard of accountability. And I mention public officials here because they should be held criminally liable for misusing information gathered during an anti-corruption legislation. We've seen this over recent years, I'm afraid. And although such behavior is criminalized in South Africa and on a statutory basis, the fact that there's been no prosecution of the misuse of information, I think is probably more to do, though that's a matter for the Commission, with the hollowing out or the dysfunctionality of South African law enforcement authorities following state capture than it is necessarily to do with, as it were, the letter of the law. So I'm underlining the point that it's not enough simply to place on statute the necessary legislation. What you have to do is follow that up with proper enforcement and holding public officials in particular to account. And then I recommend as well the implementation of additional measures to recover the proceeds of crime. For example, unexplained wealth orders, and if I may, I'll just touch upon that, as well as additional funding for regulators. Unexplained
I'm sorry,
wealth.
Lord Hayne, may I just interrupt there? You do deal in the previous paragraph 72 with the importance of the functionality of law enforcement agencies.
Yes, I have dealt with that, and that's very, crucial to what I'm saying.
Yes. I'm sorry, I interrupted you. Paragraph 73.
Here I argue for a robust and a dynamic set of tools to assist regulators with recovering the proceeds of crime, Chair. To do that more easily, so that they are more able to monitor and investigate parties that they suspect have facilitated money laundering or corruption. And I would urge that South Africa reviewed all its anti-corruption and anti-money laundering measures and reviews the ones that have been adopted by other states. Because I think there's lessons to be learned to hold, for regulators to hold criminals to account and recover the proceeds of crime. And I mentioned the example of the United Kingdom's recently introduced unexplained wealth orders, UWOs, into the regulators' task toolbox, into their powers. By unexplained wealth orders, I mean these are people have wealth that they can't explain where they come from because it's been laundered or stolen in some way and it's been hidden. And UWOs have allowed the National Crime Agency in the United Kingdom to seize assets, and this is the important point. If the owner cannot prove that they were purchased legitimately, rather than the regulator having to prove that the owner purchased the assets legitimately. This can be quite draconian, a power if it's misused, obviously, to seize people's houses and so on. But I think in this context, I think it should be looked at by the South African government and before that, hopefully, by your commission, Chair. Because if you look, for example, at the Sahara Computers instance, the court files have recently shown that 98% of Sahara's profits, and it was, I think, a Gupta-owned company ultimately, 98% of its profits came from payments made by a bogus IT company, a UWO, an unexplained wealth order, source in other words, and a UWO would have been a powerful tool in seizing the assets that could have been plainly not a purchase as a result of that company's legitimate activities. So there's a homegrown example here in South Africa under the Gupta saga where they manipulated Sahara Computers and an associated entity. And if you'd had unexplained wealth orders, you could have immediately gone and seized those assets if attention was drawn to them. So I think that introducing them here in South Africa would be, a very positive mood. Let me give you one example.
I'm sorry, Lord Hayne. Talking about unexplained wealth, in South Africa we talk a lot about lifestyle audits.
Right.
Would that be the same thing? Or unexplained wealth would be wider?
I guess it would be analogous and certainly worth comparing side by side. But I think I'm right in saying unexplained wealth orders in the UK model are much wider. And
yes.
they also have they have behind them this ability to just seize assets, which I don't think is the case in South Africa, but I stand to be corrected on that point.
Chair, I was about to raise that issue.
Oh, you were about to raise it.
We do have the notion lifestyle audit, which is a tool that is used by our revenue authorities to detect tax evasion or tax avoidance. But I understand you to be talking about a power to reside in the hands of law enforcement agencies as opposed to only revenue authorities. The other difference I think you have pointed out is that the onus in an unexplained wealth order scenario is for the holder of the unexplained wealth to prove legitimate ownership.
Yes, so that, for example, if I've suddenly built a temple, let's use an example at random, and I can't show how I've been able to fund that, then that temple could be seized. And similarly for a company, a commercial property or a property, for example, the Gupta's home in Dubai. I think that's the difference. The onus is on you to explain how you purchased this, how you have that asset, not on the regulator or the enforcement agency to prove it. So it reverses the burden of proof, if you like. And as I say, it's pretty draconian, or could be, especially if misused. But if properly used, it's a powerful instrument. And I'll give an example of that this regulation, this unexplained wealth order regulation, was used in the UK by the UK's National Crime Agency, and they required the wife of a jailed banker who was convicted of embezzling up to $3 billion in Azerbaijan to explain how she'd come to acquire certain valuable properties and assets in England worth over £22 million. And she couldn't explain that. So clearly there'd been
Yes.
a serious amount of criminal money laundering going on there.
One would assume that the enforcement of these orders is subject to regulatory or judicial oversight in any event.
I would think so. I'm not an authority on them, but you would expect, you can't have the state just going around willy-nilly seizing assets. I mean, that's undermining of the rule of law and human rights. But in the case of criminality, a suspected criminality, I think it's a powerful instrument. And certainly so far in the UK, I mean, it's a relatively recent power. I don't think there's been any cries of as it were, rights infringements. It's just been squeals from criminals who've been targeted in this fashion.
Yes, thank you.
A third distinctive factor has been pointed out to me in relation to any comparison between unexplained wealth orders and lifestyle orders, and that is that the unexplained wealth order is backed by a threat of confiscation of unexplained wealth. Do I understand it correctly?
Yes, Chair, that is the case. There's the power to confiscate, which is a powerful power. It's a robust power, and it can be quite brutal on a criminal who has got an asset that they cannot account for, and rightly so in my view, because people have got away with blue murder, quite frankly, in this whole exercise and continue to do so.
And it's more therefore than just an investigative tool.
It is definitely more than an investigative tool. It is an enforcement tool and a seizure of assets tool. So it is a very stringent and potentially enormously significant power.
In paragraph 74, Lord Hayne, you talk about funding of regulators. I presume regulators includes law enforcement authorities.
Indeed, Chair. I think this is an under sort of recognized question, that it's one thing to set up regulators, it's another thing to give them the statutory underpinning that they need to do their jobs. But it's quite different if they're not resourced properly. I touched upon this morning the question of the National Crimes Agency in the United Kingdom saying it needed an extra 2.7 billion to do its job, which the government refused to give it. But I do think this funding question is crucial. And in a country like, I mean, the truth is, the less funding regulators receive, the less investigations would take place, and the less funds recovered and the less criminals held to account. That's simply a statement of the obvious. And I think it's essential to increase funding to regulators and in particular to South African regulators and law enforcement agencies to enable them to fulfill their functions. And I realize that in the context of partly caused by this, or primarily caused by this systematic looting, the South African Treasury is pretty bare at the moment, and public spending is under enormous pressure. And I therefore think that a levy on the banks and other entities that have been conduits for this criminal financial activity, that they should pay a levy towards these enforcement and regulatory costs, because it's them that are responsible ultimately. It's not, the South African anti-corruption agencies that are responsible. It's the failure of the financial institutions and the professional enablers and the corporates concerned, as we've seen. It's their failure to stop this financial crime, and I think there should be a levy on them. And the incentive to reduce the costs of law enforcement and regulation would be that if they kept their own house in order, if they cleaned their own houses and stopped this crime, then there'd be the need for extra levies to fund extra budgets for the costs incurred by policing this crime and bringing it to heal. So I think a levy would be something that I would recommend that the Commission considered. Obviously there are complexities to it, but I don't see how, at least in the foreseeable few years, how this can be properly done in South Africa without extra resource, and since that's almost certainly unlikely to come from the Treasury, given its limited revenues at the moment and other pressing needs, then I think the banks should chip in, and so should other corporates and professional enablers.
Lord Hayne, you've mentioned the Financial Action Task Force already. Apparently South Africa is a member of that body, and you do so against the background of a statement in paragraph 76 that states should perhaps strive for increased universality, and I presume consistency and commonality or other ways of describing it, in anti-money laundering policies and procedures. Do you have any further comments in that regard?
Well, Chair, yes, I do.
Particularly that in the last sentence of paragraph 76.
I do, because it's not enough simply to have good practice following the Financial Action Task Force recommendations, let's say in South Africa. It's not enough to do that if there isn't universality of imposing these standards in all countries. And I think it's essential, for example, to raise the standard in states where financial corruption is endemic. I think of the United Arab Emirates, particularly Dubai, China, Hong Kong, are examples, possibly the principal ones. Then offshore tax havens in the Caribbean and elsewhere where the problem arises as well. But these are the big giants involved. And the Financial Action Task Force has proposed a set of recommendations aimed at preventing, detecting and sanctioning money laundering that should be adopted by all states and that should underpin national legislation on this issue in every country in the world. And I think it would be good if through your commission it was considered whether the South African government should appeal to other states, itself having adopted these standards, to do so as well.
In paragraph 78 and following, you deal with the issue of mutual legal assistance. Be grateful if you would explain that concept. We will, Chair, be leading independent evidence on this matter in due course.
Yes, indeed. I mean, by mutual legal assistance treaties, these are designed to prevent criminals from escaping justice by relocating themselves and their assets to others' jurisdictions. And I urge that states work together to ensure criminals are held to account wherever they are in the world. This seems to me to be absolutely essential. And based on the reported locations of the funds stolen and laundered by the Guptas, cooperation between South Africa, Hong Kong, the United Arab Emirates and India is the priority. So there's got to be much better mutual legal assistance arrangements there with those 4 jurisdictions in order to make immediate progress. That's absolutely the priority.
And you talk about mutual legal assistance treaties in paragraph 80.
Yes, as I explained, these are designed to increase cooperation, exchange information, get criminals back into their home jurisdiction, and they can provide their enforcement agencies and indeed the state with the information they can't normally get through inter-law enforcement cooperation. It actually needs cooperation between governments and their regulatory and enforcement agencies, not relying on the courts to do it, which is, much more bureaucratic, time-consuming, and much clumsier. And that's no criticism of the courts; it's just in the nature of the beast. And I think the types of consistent assistance that could be requested within a mutual legal assistance treaty include serving proceedings, obtaining special procedural material, for example, records held by banks and accountants, and additionally searching and seizure of evidence, and then the freezing or confiscation of assets. So all these things are possible, but made much more difficult, if unachievable, unless these treaties are in place.
In paragraph 81, you make further comments, Lord Hayne, in relation to mutual legal assistance treaties, and you refer to a mutual legal assistance treaty and extradition agreement with Hong Kong, signed on 20 February 2009, and you state, but has yet to be submitted to Parliament for ratification. As authority for that, you cite in a footnote a Department of Justice and Constitutional Development document in footnote 46. Do you know perhaps the date of that document, whether that still is the position?
I don't, I'm sorry, Chair, but I could try to find out and let the Commission know if that would be of assistance.
I'm reliably informed by Mr. Chaskelson that it is still the case.
So if that being the case, this is now 10 years ago, Chair, and Hong Kong is one of the, if I could put it this way, dodgy jurisdictions, which I have repeatedly mentioned, and I don't know what the reason for that is. President Zuma's been former President Zuma's been out of office now for nearly 2 years, and if that was one of the reasons for why it was delayed, I don't know, but there's no reason why it should be delayed any further.
And then you speak in paragraph 81 also of the enforcement of such agreements and the utilization of such agreements where they do exist.
Yes, indeed, and that's really important. It's no good having it if you're not actually enforcing it and using it. For example, there's one with India, but we know the Guptas have weddings, buy temples, have homes in India, and yet they have not been returned by the Indian government despite the South African authorities wishing to see them back in this country facing justice. So it's no good just having one of these treaties. You've actually got to implement it.
Then in paragraph 82, Lord Hayne, and following, you deal with extradition agreements along the same lines as you have dealt with mutual legal assistance treaties.
Yes, I mean, like mutual legal assistance treaties, Chair, these are another type of interstate, inter-country mechanisms that can be utilized in agreements to hold criminals to account and bring those who've fled overseas along with their laundered funds back home to justice. So I think that it's important that those are pursued and that those those criminals who have committed, for example, state capture offences in South Africa are prevented from committing further offences, and their ill-gotten gains are returned. And all governments must ensure that their country doesn't provide a safe haven for the perpetrators of state capture. Again, looking to seek refuge beyond the reach of international justice, some of the main culprits, and these names crop up, I'm afraid, Chair, time and time again: Dubai, Hong Kong, and, as I mentioned in passing but want to stress now, tax havens in the Caribbean. They're also the rogues in this rogues gallery of international financial crime. And that requires the express criminalization of money laundering and other types of financial crime as extraditable offenses. Very important, extraditable offenses and agreements between states to extradite persons who commit these offenses. That's absolutely essential.
You sound a note of caution in paragraph 85, where you say that it must be recognized that caution must be exercised in relation to states that do not observe the Universal Declaration of Human Rights in their justice systems.
Yes, I'm glad that that's been drawn to my attention, Chair, because you can see abuses of such procedures. I mean, it's well known, for example, that the Russian mafia and criminal elements in Russia use red notices under Interpol procedures to just slap one on individuals willy-nilly, who then get arrested, sometimes embarrassed in doing so when they're quite innocent. And so it's important that it's done with some care, and that Interpol actually, don't just act on a red notice request willy-nilly, as they have done repeatedly. That's well documented. And I could send examples of that to you if that were something you might be interested in, Chair.
What is a red notice request?
Well, this is basically where an international person is wanted notice, essentially. There's another term for it which escapes me at the moment, but they are ways of Interpol acting properly and legitimately to track criminals down who've gone to another country, and they should be supported in that and encouraged. But they've also been abused, and there's been a series of cases where they've been abused. So it's got to be done, properly, and not abused by, as I say, Russian criminal elements, as has been the case. But there's also a question here, which I mentioned, the existence of extradition-free havens, and I touch upon this in Exhibit QQ, because there are very few countries with...
QQD.
QQD, sorry. There are very few countries with absolutely no extradition treaties. It's quite common for some countries to really, if ever, extradite their own nationals. France and Russia are examples of that. There are also many, many countries with whom South Africa has not current extradition treaties, and where South Africa has to proceed using ad hoc and actually non-enforceable requests, and which are slow and can allow plenty of time for the criminal concerned to evade justice for many years, flee to another jurisdiction, for example. So I think this extradition free haven problem is one that I think it would be good to consider in the context of your deliberations, Chair. And perhaps if I could just add briefly the point in paragraph 86 that it's not good enough just to have extradition agreements. States must be willing to cooperate, and cooperate quickly, to ensure that criminals are held to account. And I've suggested that ad hoc agreements are reached with respect to specific individuals responsible for serious financial crime in the interim to speed the process up prior to negotiating and putting into statute extradition treaties, which take a bit longer.
Is there anything you wish to add, Lord Hayne, in relation to extradition agreements?
There is, if I may, going back to paragraph 84, Chair, I'm particularly concerned with the question of the UAE, the United Arab Emirates, and specifically Dubai. As has been mentioned before, the extradition and agreement and mutual legal assistance treaty between South Africa and the Emirates is a positive step forward. But it's taken 8 years of negotiations, and the Guptas are yet to be extradited, and they're currently free to spend their billions reducing any amount that might conceivably be repatriated back to South Africa later on. And the question is, why has this happened in Dubai?
Maybe I must just mention, Lord Hayne, that I recently had a meeting with the Minister of Justice, and I asked about what's happening in regard to that issue. And he certainly did tell me that there were certain challenges. I can't remember the details, but I know that I think the following day there was some public statement, or there was something in the newspapers that the Ministry of Justice had either issued or the newspapers had taken up. That was, I think, around about the time when the United States announced some action against Gupta-linked businesses and the Gupta family. So I certainly did raise questions to say what's happening. And he did say that there were certain challenges, but he did say that they were pursuing the matter. I can't remember the details, but it is taking long. That's true. It is taking long.
Indeed.
Yeah.
If I may assist there, Chair, because I was there.
Yes, you were in
when
that
that
meeting.
Communication was made.
Yes.
And it mirrors the concern raised by Lord Hayne that despite efforts, the level of cooperation appears to be lacking. I don't want to create an international incident, but that's the fact.
Yes. No, I think that's true. Yeah.
And perhaps, Chair, if I might just briefly add, the question I ask in my submission is, why is this happening? It seems to me either the government under the ruler of Dubai, Sheikh Mohammed bin Rashid Al Maktoum, is willfully sheltering a family that has looted astronomical amounts from South African taxpayers, or the South African authorities don't have the capabilities or maybe political will to insist that the Guptas are arrested and returned to South Africa to face trial. It's frankly astonishing to me that hasn't happened, given everybody knows where they are. So I think the Dubai ruler, I think it would be very helpful if he accounted publicly for why this hasn't happened and explained whether it's to the Commission or more generally.
Yes.
Lord Hayne, before we conclude your evidence, as you do in paragraph 87 and 88 of your statement, you've indicated that you wish to deal with a few other issues that are not in your statement. The first of those is the action taken by the US government to impose sanctions on the Gupta family, and your response in relation to your own Department of the Exchequer in the United Kingdom.
Yes, Chair.
If I may just, I'm sorry to interrupt once more, just refer the Chair to the documentation, which appears at tab 38 and 39 in bundle QQB. That's the second large bundle before you, Chair.
Yes, thank you.
Pages 789 and 791, tabs 38 and 39. Do you have that?
I do.
Did you say tab 39?
38 and then 39.
Yes, and under 38, what paragraphs? Oh, no paragraphs there. I thought you were referring to paragraphs. I thought you were referring to paragraphs.
My apologies. Yeah,
Yes.
tabs.
Oh, tabs, okay.
Yes. I'm sorry,
Okay,
Chair.
I am at 38.
So 38 is a letter I sent to the British Chancellor of the Exchequer, the British Finance Minister, on the 11th of October 2019, following the decision by the United States government to impose sanctions on the Gupta business family and one of their associates in relation to the subject we are discussing, the massive corruption and money laundering. And I refer there to robbing South African taxpayers of over £500 million. And I asked specifically that the British government urgently did exactly the same, followed the American lead. And I named Rajesh, Atul and Ajay, the Gupta brothers concerned, and gave their identity numbers, which were provided to me on a previous occasion, and stated the address where they live in Dubai, and also pointed out that they travel, including to India, and that they seem to do so quite freely, and asked that that Britain do exactly the same thing, impose similar sanctions because of all the reasons we've discussed, the shadowy shell companies, the lucrative contracts from state-owned enterprises, and so on. And the important thing about these US sanctions is that they forbid all US entities from doing business with the family or handling their assets. Now that would include banks, and include the Bank of Baroda, by the way, even its Indian based and principal operations. So those are pretty powerful and forbidding sanctions to cross. So I was asking that the same type of sanctions were introduced by Britain, and that the government imposed the same ban on UK entities, including London-based banks like HSBC, Standard Chartered, and the Bank of Baroda, our friends in the banking world, which have been culpable for all this money laundering. And asked that the Indian and Dubai, that the British government requested the Indian and Dubai authorities to do the same thing, and I might have added Hong Kong too, which I will now. And I think, you know, the South African President, Cyril Ramaphosa, has been very clear about leading the fight against corruption and state capture, and I think he needs much more help from countries like Britain, as well as other countries around the world, because they have been conduits for the Guptas to move their criminal millions globally. The reply I got, Chair, which is at Exhibit 39, on I think page 791, frankly,
Yes.
was, to put it mildly, very, very disappointing. I received this letter on the 5th of November. It hasn't been publicized yet. And I placed it on the record, which frankly is a weak and pathetic non-reply, saying, no, they're not intending to follow the US sanctions precedent, claiming they didn't have the same powers in the UK. Well, if not, why not, is my question. And if I may say so, I was a government minister for 12 years in Britain, including 7 years in the cabinet. I recognize this type of civil servant sophistry. It is a kind of words designed to give, you know, warm sort of feelings, but actually do nothing at all. And it's simply not good enough. I think the British government should do better. I've expressed directly to the minister concerned. I didn't even have a reply from the Chancellor himself. I get a reply from a junior minister in the Department for International Development. It's an important department, but not as powerful as the British Treasury, to whom I wrote. No, it's just not good enough. And I think that, why are there not sanctions being imposed by Dubai, India, and Hong Kong? And then I would like to, if I can, Chair, ask the question, has the South African government requested this? Has the South African government requested that the UK and other jurisdictions where this money laundering has been documented as flowing through, and I've repeatedly mentioned them, why they are not imposing sanctions as well? I think we deserve an answer, because it's not good enough to simply give these bland and as I say, pathetic non-replies, as I had, sadly, from my own government. Sanctions are a powerful tool, and we've seen them applied elsewhere in the world, and they should be applied to the Guptas as well, in my view.
Lord Hayne, there were 3 other matters that you drew to the attention of the legal team that you might still wish to mention. Some of them you have dealt with: the question of asset recovery, the predominance in the international finance environment of new digital methods, being ahead of the game. You've dealt with that to some extent, and the issue of the levy on global corporates, you've mentioned that as well. But if there's anything you wish to add in that regard, or in any other regard, please do so.
Well, perhaps, Chair, just briefly to reinforce the points that have been made earlier, that I've sought to make earlier. I've been struck at how slow action has been from South Africa. And I know it's emerging from this terrible era of state capture, and the institutions have been either dismembered or their capacity undermined, and the resources are slim. I understand all that. But, it's a fast-changing environment, this environment of international crime, with the new digital opportunities for it. And crooks wise up all the time. And I think that it's important that...
and they act fast.
And they get
They
fast.
act fast, yeah.
And they do indeed. And they're doing it all the time through cyber crime and all sorts of other new phenomenon, or relatively new phenomenon. It changes almost week by week. And it's essential to move quickly. And I understand why due process is needed, but I just say, as a friend of the South African government, and particularly its president, whom I admire and I think is widely respected across the world, is President Ramaphosa. I just think they need to make decisions more quickly and act more quickly, and I hope that might be something that your commission could investigate. I just reinforce the need for the levy on global corporates, given the lack of resources that there are for the public purse in South Africa. I think that would be, and I wonder too what the follow-up will be, both by the Commission and in any recommendations you might make by the government. We won't have then months of consultation on what your Commission might recommend, followed by parliamentary debates, followed by still more months of consultation, something beloved of public administrations, and I experienced this myself as a government minister, very frustrating. Endless process going round and round in circles, instead of just immediate action, is what I would urge. Before I perhaps conclude my remarks on paragraphs 87 to 88.
Well, what I can tell you in regard to what will happen or how quickly action may be taken after the recommendations of the report of the Commission has been presented to the President is that As you would know, this commission has its origin in a report of the previous public protector, and in her remedial action, which required that this commission be established, she had also directed that within 14 days after the report has been made available to the president, I think, should send to Parliament information as to what he would do with regard to the recommendations, which seems to give an indication that the desire was that there should not be a long delay after the report of the commission has been submitted to the president. And that was, if I recall correctly, repeated by the High Court in Pretoria when it made an order which effectively reflected the remedial action of the public protector. So there is that obligation on the part of the president to make up his mind as soon as possible, at any rate within the time given, unless that time is extended by the court to give him more time, because it may be that 14 days after the report might be too short when the commission has sat for a long time listening to evidence. But there is no doubt that the idea is that there should not be the kind of delay that has been seen in regard to some commission's reports, long delays before any action is taken. So, and I think the current president has committed himself to acting, without delay after the report has been given. But obviously, he will have to digest the report and get advice and make up his mind what his response would be to it before that is made public. But that's how much I can tell you.
Well, that Chair, that's encouraging, and I'm grateful for
yes.
that update, which is encouraging indeed.
Thank you.
Quite apart, Lord Hayne, from the will to act, which is the subject matter of the exchange between you and the Chair now, and his assurances in that regard, there's also the other question that you raised in your evidence that perhaps should not be lost sight of, and that is, given the sophistication of the international money laundering network and the tools at its disposal, it's important that South Africa's own law enforcement agencies are equipped to, as you put it, stay ahead of the game, both technologically and from a capacity point of view.
Yes, indeed, Chair, that is critically important, and it's difficult enough for much better resourced and better rooted agencies in the UK to do this, such is the nature of cybercrime and financial crime, and its accelerating speed around the world. And in South Africa, of course, it's difficult to keep up, but somehow it would be good if that were possible.
Then,
well, I'm sorry, Mr. Pretorius. Going back to the question we were discussing a few minutes ago, the one thing which could potentially delay action on the findings and recommendations of this commission might be litigation, because there are very many people out there who like what this commission is doing, but there are also very many people out there who don't like what this commission is doing. And by the nature of the investigation that this commission is doing, and if it is to make certain findings, one can almost be sure that certain people would want to go to court. And that could cause some delay, but it may well be that, for example, the president to whom the recommendations would be made and the report would be submitted, that he might have to make up his mind on certain recommendations to say, well, if there is no court challenge about these ones, I would want to go ahead and implement these. But he might just have to make up his mind about some, because I don't think anybody would be surprised if there is a lot of litigation to challenge findings of this commission.
Thank you for that update, Chair. I'm not sure that it's really for me to comment on that, except I have observed with some frustration, and I'm sure it's not as much frustration as you yourself have observed, being at such a high position in the judicial system, the way the courts can somehow be, in the process of law, be used by the bad guys, as opposed to allowing the good guys to proceed and establish probity and integrity in our public administration system.
Mr. Pretorius.
Yes, that raises a number of constitutional issues, but perhaps that's a debate for another time.
Yeah.
In paragraph 87 and 88, paragraph 88 of your statement, Lord Hayne, you summarise your submissions. We've heard the evidence, and perhaps you wish to either summarise or make the concluding statement that you do in paragraph 88.
Well, thank you, Chair. I'm not sure if this is appropriate, but could I just say, by one of these historic ironies, that I've found myself appearing before you as Deputy Chief Justice, and my mother in 1963 in Pretoria was assisted at the trial, at his trial, 15-year-old Dikgang Moseneke, the former Deputy Chief Justice, your predecessor.
Oh, that's interesting.
He used to love a bar of chocolate, so she always took him a bar of chocolate every day, as well as food and soup and so on. She didn't know what became of him, and he didn't know who she was, that I was her son and that I'd been active and prominent and so on. So I'm sure she's recently died, but I'm sure she would have loved the symmetry of me appearing before you, just as she'd supported your predecessor when he was a young boy and before he was dispatched to Robben Island to serve 10 years. So apologies for that brief interlude. But
no, that's fine, yes.
My recommendations to the Commission, Chair, just to summarise briefly. First of all, increase transparency around beneficial owners of corporates and strengthen the programme for auditing and due diligence conducted by banks and professional enablers to ensure that they're fully complying with anti-money laundering legislation and policies. Secondly, increase the sharing of data between banks and professional enablers, between banks and the state, so that there's greater visibility around the risk profile of customers and transactions. Thirdly, create additional penalties, both at an organizational level and at an individual level, for banks, their management, and professional enablers who fail to self-police and act in accordance with anti-money laundering legislation and procedures. Fourthly, to join the Extractive Industries Transparency Initiative, the EITI, so that there's greater transparency and accountability around the operation of those industries, and consider extending those to other sectors. Fifth, increase the transparency around the Black Economic Empowerment Programme to ensure that the legitimate aims of this initiative, and important aims, are not subverted for the personal gain of a minority of criminals. Sixthly, ensure proper utilization of anti-money laundering and corruption legislation in existence, as well as implementing additional legislation to better hold public officials to account and assist with the recovery of assets, coupled with increased funding for the regulators, both state funding if possible, but also by private levy, private corporation levy, banks and so forth. 7th, fully implement all of the Financial Action Task Force recommendations. 8th, increase mutual legal assistance between states. 9th, encourage extradition agreements between states. And Chair, finally, can I say that, that making the changes needed to combat financial crime, investigate potential corruption and repatriation of stolen funds will not be easy. However, the people of South Africa deserve better than the obscene looting and devastation caused by state capture, and I hope that the recommendations referenced in this report will also be recommended and considered by your Commission and then implemented by the government. Because I think, as a friend of South Africa and as a former South African myself prior to my enforced exile a long time ago, South Africa's had and still does a corruption near-death experience, and that must not be repeated and must be eradicated if the country is to survive and prosper in the future, and if the values of the freedom struggle are to be realized. I thank you.
Thank you, Lord.
Thank you very much, Lord Hayne. But before I let you go, can I go back with you to the question of lifestyle audits and unexplained wealth? What do you think of a proposal to the effect that, as far as possible, as part of trying to limit chances of corruption and limit the extent of corruption and so on, and also as measures aimed at helping to pick up indications of corruption, what do you think of a proposal that would say, one, public officials, maybe from a certain level, because maybe if it's everybody, it might be unmanageable practically, from a certain level upwards, should only be employed by government or government entities if they have agreed to undergo a lifestyle audit, which must be done regularly, maybe once every 2 years, once every 3 years, or whatever the intervals are, just to see whether there is anything that calls for investigation. But also to say, with regard to entities and businesses that want to do business with government and government entities, directors of those entities or companies that want to do business with government should be prepared, if they want their company to be considered, to agree to lifestyle audit or something of that kind. Have you got any views you would like to share with me on that? And is that something that you may know of in other jurisdictions as something that maybe has been tried?
Chair, I very much applaud the principle and see it as complementing rather than being in some ways sort of contrary to unexplained wealth orders, because unexplained wealth orders are of a different character. I think the principle of lifestyle audits for all public officials, particularly the senior ones, I'm not sure the cleaner would need that, but certainly the CEO or the senior executives would. The people likely to be involved in public contract negotiations and so forth, and giving planning permissions and all those kinds of licenses and all those kinds of things. I think that would be a very good thing, and where South Africa could maybe set a bit of a gold standard in this respect. And certainly as far as the private sector is concerned, or those businesses that want to do public work for the government at all levels, national, provincial, local, municipal, city, and so on, that they should be transparent, and that would, I think, be very valuable indeed. I mean, in all of these things, obviously, it needs to be proportionate, because I found in my time of government, and this may or may not be relevant to the South African situation, but certainly in Britain, there was a tendency to, and by the way, I'm a big fan of civil servants. I couldn't have done my job as a government minister without diligent civil servants supporting me and implementing the decisions that I took. But I think there's a tendency to become over-bureaucratized and over-process-driven, where you take a principle like a lifestyle audit for both public officials and for potential beneficiaries of public contracts, and you kind of complicate it and put bells and whistles on it to the extent that it becomes a superhuman achievement to be able to tick all these boxes. You don't want that, but you do want to know whether people are having money stuffed in their back pockets that they shouldn't. So I very much applaud that proposal from you, Chair.
Yes, no, thank you. I thought I would just put that to you for your views. There's going to come a time in the life of the Commission where we will focus on possible recommendations, and I will hear a lot of submissions from different stakeholders and so on. But I thought now that you are here, maybe you could give me the benefit of your views. Thank you very much.
No, thank you. And if, as I indicated earlier, if there was any specific areas of expertise that you wanted that I could maybe assist on, not necessarily myself, but from some of those who helped me draw up the solution,
yes,
and in a sense educated me about the problem, I'd always be happy to help.
No, thank you very much. Thank you very much. Mr. Pretorius, are you done? Yes. Well, it remains for me, once again, Lord Hayne, to thank you very much for taking your time to come and share with the Commission the evidence that you have shared, what you have experienced and what you have gathered in the public domain, which I think deserves a very close examination by myself. I will certainly look at them. Some of the proposals you have made appear to me to be quite attractive. I will hear more and will hear from people in the industry and hear what they have to say, but on the face of some of them, certainly they appear quite attractive, and I thank you for having come all the way to assist us. Thank you very much.
Thank you. As I said at the beginning, it's been a privilege, and I'm grateful to you.
Yes, no, thank you very much. I have no doubt that the Commission will look at your offer very closely, and where we think we could make use of your assistance through other people, that we would approach you and see if you can continue to assist in whatever way.
Thank you.
Thank you.
Thank you, Chair.
You are now excused. Thank you very much.
Thank you.
That's the end of the proceedings for today, isn't it?
For today.
Yes.
And I haven't yet ascertained the state of play for tomorrow, but we'll communicate with you as soon as possible.
I've been informed that there will be 2 witnesses tomorrow.
Yes.
Reverend Frank Chikane will come and give evidence tomorrow, as well as I think it's Colonel General Matakata. I may be having the title wrong, but
yes.
I've been assured that she will be coming also tomorrow.
Yes, Chair.
So we will start at 10 o'clock tomorrow morning.
Thank you, Chair.
Thank you. We will therefore now adjourn for the day. The proceedings are adjourned.
All rise.